Good afternoon and welcome to the Appellate Division First Department, which is now in session. We're happy to have you here for our virtual oral arguments on October 6, 2020. I am now going to call the calendar. The first case is People versus Randy Colon. Appellant?
Yes, for appellant, we have these here.
Okay, you have 7 minutes to argue and 2 minutes for rebuttal. Respondent.
Good afternoon, Your Honor. Stephen Kress for the respondent.
Okay, and you have 7 minutes also to argue. Oliveri versus Tomlin is submitted. B. Melinda versus Jonathan P. is submitted. Castillo versus New York City Transit Authority is submitted. Tusu versus Leone is submitted. People versus Manuel Encarnacion, appellant.
Good afternoon, Your Honor. David Bernstein for appellant.
Okay, you have 6 minutes to argue and 2 minutes in rebuttal. And the respondent, People.
Respondent present, Deborah Morse for the People.
Okay, a little hard to hear you. Hopefully you can fix that up. You have 6 minutes for your argument. Next case, Aberger versus Camp Loyalton. Appellant?
Mitchell Frankel for the appellant, Your Honor.
Okay, you have 8 minutes to argue and 2 in rebuttal. The respondent?
Eric Koplowitz for the respondents, Your Honor.
Okay, and you have 8 minutes to argue. Romano versus One City.
Good afternoon, Your Honor. Eric Popkin on behalf of Romano, plaintiff appellant.
Okay, you have 5 minutes for your argument and respondent.
Good afternoon, Your Honor. Megan Lawless for the respondents in this case.
Okay, you also have 5 minutes to argue. 3P-733 LLC versus Davis, appellant.
Good afternoon, Your Honor. Eric Warner here on behalf of plaintiff appellants, 3P-733.
Okay, you don't have to go through all the names.
Thank you, Your
Honor. You have 6 minutes to argue. That will take 6 minutes to go through. And the respondent, are you here too?
I am, Your Honor. Russell Morris for respondent.
Okay, and Mr. Morris, you also have 6 minutes to argue. The next case is People, I believe it's Gary Joseph, not the way it's written on the calendar, Joseph Gary, is the respondent here.
Appellant's here.
The appellant, I'm sorry, the appellant.
David Clem for appellant, thanks.
Okay, you have 4 minutes to argue and 1 minute on rebuttal. And the respondent?
Respondent is also present, Your Honor.
Okay, and you also have 4 minutes to argue. Mareem versus Metropolitan Club are the appellants here?
Good afternoon, Your Honor. Michael Fettner for appellants.
Okay, you have 5 minutes to argue, and the respondent?
Good afternoon, Your Honor. Arthur Robb for respondent.
Okay, and you also have 5 minutes for argument. Cohn versus Civ Paget.
Good afternoon.
Appellant.
Morris Cohen for appellant is here.
Okay, you have 6 minutes and 2 minutes in rebuttal. And the respondent?
Good afternoon, Your Honor. Matthew Naparty for respondent.
Okay, and you also have 6 minutes for your argument.
Thank you.
Philip versus GOLA Inc. is submitted. People versus Robert DiPaolo, the appellant. Isn't that Miss Adelson? I see you. You have to unmute.
Yeah, okay.
Okay.
Adelson for appellant.
You have 7 minutes to argue and 2 minutes for rebuttal. And the respondent?
Yes, John Hughes for the People for respondent.
Okay, and you also have 7 minutes.
Thank you.
U.S. Bank versus Abrahimzadeh is the appellant here.
Appellant is present, Your Honor.
Okay, you have 5 minutes to argue, and the respondent did not ask for any time. Next case is Lenahan versus Chandler, which is submitted. People versus Yolanda Walton is submitted. Bradno versus David is submitted. and Gonzalez versus Miles is submitted. So let me just remind you, as I believe the clerk instructed you, for the attorneys, please keep your microphones muted until your case comes up for argument. I'm going to do my very best at keeping the time as accurate as possible. So if you have a watch, you can sort of follow along. And I, of course, especially, we would never want to interrupt judges when they're asking questions, but especially when we're virtual like this, there's sometimes a 1 or 2 second time lag, as I'm sure you're all aware. So just try to, keep an eye on what's going on, and just stop if you think somebody is speaking over you. We'll all try not to do that too much. And so far, I've had pretty good success with this, so hopefully today will go well also. Okay, thank you all for being here. And the first case that we're calling for argument is People versus Randy Colon, and we are ready to hear from the appellant, please.
Good afternoon, Marika Meese for appellant Randy Colon. Just confirming that I have 2 minutes for rebuttal.
Yes, you do.
Thank you, Your Honor. I will be addressing the Batson and Buford claims from my brief, which are points 2 and 3. As to the Batson claim, the court below erred in handling Colon's Batson claim for 2 reasons. First, the court accepted the prosecutor's proffered race-neutral explanations for striking 2 jurors, but then cut counsel off and did not allow defense counsel to make a step 3 showing that those proffered reasons were in fact a pretext for discrimination. And second, as to the 1 juror, Perez, where defense counsel was able to make some record, the court never made a final step 3 ruling as to whether or not the proffered reasons were in fact pretextual. Going first to Perez, the prosecutor had claimed that...
How are you, Ms. Meese?
I'm very well, Judge. Thank you.
Good to see you.
You too.
So, Ms. Meese, you said that the judge cut the defense attorney off in the attorney's attempts to make or argue as to the prosecution's race-neutral basis for striking that juror. I did not see that in the record. Exactly how did the judge cut the defense attorney off?
Well, counsel was in the middle of giving reasons as to juror Perez, which was the first juror he had addressed. And in the middle of giving those reasons, where he was showing that, in fact, the prosecutor had asked many questions of her, and that her information she gave about her job was what would be expected for that type of job, the court intervened and said, this is all on the record, and then turned on to proceed with jury selection, giving counsel no further opportunity to make his full step 3 showing, nor did the court actually rule on whether what counsel was able to say as to Perez was sufficient to show that it was a pretext for discrimination.
And so at that point in time, did counsel make any further objections or state to the court that he was in fact objecting to the prosecution's race-neutral basis?
No, Your Honor, but implicit in the way the court handled it, the court was not hearing any further on the subject and clearly turned on to proceed with jury selection. So counsel was not afforded an opportunity to say anything further in that regard. But the court never actually went to step 3 and never made a final ruling.
So once the court continued on, should counsel not at that point simply stated that I continue to have an objection, or Judge, I have an objection? I mean, once the attorney didn't say anything further, why would not the court believe that the attorney was accepting the court's determination and had no further objections?
Because the court, in fact, made no determination. The court didn't say, I agree with the prosecutor's reasons. I'm finding their explanation credible. It just simply stopped defense counsel from making further argument and then proceeded with jury selection.
And
so while it might have been
a recitation of the prosecutor's statements as to why it was race neutral would not be sufficient to form the basis of a decision by the court?
Well, the court reasons. It was defense counsel that was addressing the proffered reasons given by the prosecutor in saying the prosecutor claimed they didn't learn much from her, but in fact, they learned a lot from her and they asked more questions of her than the defense. Turning to another point raised by the prosecutor, defense counsel then showed how Perez's claimed curt answers about her job were in fact all one might expect of that type of job where she was cleaning in the theater and had been fully responsive to questions in that regard. So the court never then said, I agree with the prosecutor and find that the proffered race neutral reasons were not a pretext for discrimination. And it never did that final step 3 analysis and decision, which is a required part of Batson. Similarly, with the second juror to whom the prosecutor had raised objections, had raised proffered race neutral responses, defense counsel never got to say anything. And the record belies all of the reasons given by the prosecutor. Rivera was claimed to have been aloof and give minimal answers about his family and be not responsive.
As to that juror, why do you state that the defense attorney never got to say anything? Did the defense attorney make any attempt to say anything?
Well, he was in the midst of addressing the first of 3 jurors struck when the court stopped him from doing so and turned to continue jury selection, thereby clearly indicating to counsel that he was done with hearing the issue of this Batson challenge, even though the step 3 inquiry had never been completed and a final ruling had never been made. And turning to the Buford claim, the court erred in refusing to conduct inquiry of any of the 3 jurors who had specifically stated in response to the court's inquiry that they had flights scheduled that would interfere with deliberation.
There was one juror who had a work-related, I think she had a large, some work-related issue that may have detracted her ability to focus on the case. On that particular juror, there was a Buford inquiry. There was an inquiry of her, and she stated that she would not allow her concerns about the job interfere with her jury service. The other 2 jurors stated that they had flights, scheduled flights. Counsel, from my reading, never asked for any inquiry as to those 2 jurors, the jurors who had the impending flights. Isn't that correct?
Well, yes, Judge. As to the first juror, Gallo, the one who had the work-related incident, the court did address that in a Buford inquiry, and she said that she could remain fair. However, she thereafter raised another concern that is unclear in the record. And then when the court asked if starting deliberations on Wednesday would be a problem, she also responded with a scheduled flight. So that prior inquiry did nothing to satisfy whether these additional concerns would have rendered her grossly unqualified to serve. And a subsequent inquiry of her was warranted. As well, the 2 other jurors had responded as to flights on Thursday and Friday, and counsel requested an inquiry as to all of them. At the moment that the flight concern was being addressed, or that the other unknown record concern was being addressed by the court officers interjected with the flight information. And at that time, defense counsel sought inquiry that would have covered all 3 jurors. And what he persisted in requesting, and the court instead adopted a sort of wait and see approach, saying it was too premature. But at that time, the court had asked the jurors if they had a concern. And when they responded that they did, that was precisely the appropriate time to conduct an inquiry and to see whether those concerns rose to the level of allowing them to continue to deliberate fairly and impartially as the law requires.
Counsel, we'll let you address anything else during your rebuttal. Okay, thank you very much. Mr. Kress?
Yes, thank you very much, Your Honor. May it please the court, Stephen Kress on behalf of the people. We obviously disagree about counsel's assertion that the court did not allow defense counsel below to make a record on the step 3 of the Batson challenge. This is not a scenario where the court expressly ever denied the application. In fact, as counsel started to make his step 3 showing, or step 3 arguments. All that the judge said was, look, you don't need to repeat the question and answer from the voir dire, which is really all that counsel.
So why does that not constitute? Why did that not constitute the court stifling the attorney at that point in time? Was it not apparent to the attorney that there were not to be any further arguments by him?
No, in fact, immediately after making that comment, the judge says, "Where are we?" And at that point, counsel easily could have said, "Well, Judge, actually, I was in the middle of giving my responses to the people's explanations. I'd like to continue." In fact, he was required to do that under Smokum, which is one of the cases we cite in our brief. No, there was no reason why he could not have continued to make his arguments at that point.
Did the court actually make a determination as to Batson? Did the court actually go through all the steps as to why it was race neutral?
So the court it did say that I accept the prosecutor's explanations, although defense counsel didn't seem to think that constituted a ruling on all step 3 or on all 3 steps. And after that, defense counsel moved on. When the judge said, "Where are we? Let's continue with jury selection," defense counsel never said anything further. So there was nothing else.
Was the court required to make any further findings or make any specific findings other than saying I accept the prosecutor's race neutral arguments?
I mean, I think after defense counsel seemed to have abandoned his application, I don't think the judge had to say anything further beyond that. And I'll turn to the Buford point after this. So I think we disagree that there was, counsel said that there was no inquiry done in this case. As the court pointed out, there was one done with Ms. Gallo, and there does appear to have been an off-the-record inquiry as to the other 2 jurors. If counsel actually below raised this issue and said, "I know what they said when we inquired," so it does appear that there was some inquiry. And the only thing that counsel raised after that was this issue of the court advising those jurors with flights that potentially the court could have their fees waived. And the court never actually denied that request. He actually said—
But never did it. But the court never actually never advised the jurors of that.
That's correct. He said, I don't think we have to do that at this point, and that was perfectly reasonable. This was coming up on Wednesday morning. The jury hadn't started deliberating yet. Defense counsel himself thought that this was going to— they had a lot of evidence in front of them, and it was entirely reasonable for the judge to say, look, let's start deliberations, and we'll cross that bridge when we get there. He could have done it Wednesday night, knowing that at least one of the jurors had to leave on a flight on Thursday.
The jury was charged on the Wednesday. Is that correct?
Yes, that's correct, Your Honor.
And they had flights on the Thursday. Is that correct?
Yes, at least one of them did.
And the jury was out for, what, 4 hours, something like that, if that?
About that, yes. And in fact, they sent 3 notes during deliberations and actually acquitted the defendant of the escape charges that had been brought against him. So certainly this is not a case where you can look at the record and say that their flights meaningfully influenced their verdict. And unless the court— or before I rest, actually, I will also just make a note of really what was overwhelming evidence of guilt in this case. The 2 eyewitness IDs and a very strong corroborative ID from the co-defendant's girlfriend. And unless the court has any other questions, I'll ask that the judgment be affirmed.
Thank you very much. Ms. Mace, you have 2 minutes to rebut.
Thank you, Your Honor. As to the Batson point, when the court said, "Where are we?" that was clearly directed to the clerk when he was asking what juror number are we at in going through the challenges. There was no opportunity then for defense counsel to interrupt and say, "I'm still in the middle of trying to make my arguments in response at step 3. As well, when the court accepted the prosecutor's race-neutral reasons, that was at step 2. Thereafter, defense counsel has to be afforded under step 3 a chance to rebut those race-neutral reasons and show that they are a pretext for discrimination. The court never fully allowed that to happen and never made a final step 3 showing. In that regard, the court can't be afforded any deference because it never made that necessary step 3 credibility determination. So accepting the explanations at step 2 does nothing to cover the required 3 steps of Batson. And as to the Buford point, there is no evidence in the record that there was an off-record inquiry as to these 3 jurors with their scheduled flights. Clearly, the court knew how to conduct a Buford inquiry and to do it on the record as the law requires, because it did so with Gallo for her earlier concern about her work. And the fact that the judge just let this hang after asking the jurors specifically about their concerns more likely would have impacted them and made them feel that they were rushed to deliberations and rushed to return a verdict before their scheduled flights. And if the court has no more questions, I will rely on my brief for the remaining arguments.
Thank you both very much for your arguments. Have a nice afternoon.
Too.
The next case for oral argument is People versus Manuel Encarnacion.
Good afternoon, Your Honors.
Good afternoon.
May it please the court, David Bernstein, Office of the Appellate Defender, on behalf of Manuel Encarnacion. I want to talk about 2 ways in which counsel was ineffective, but before I do, I need to emphasize that this was a very thin, very triable case where there was no forensic evidence, no biological evidence, no eyewitnesses, just a complainant with extreme credibility problems. The people tried to fill out their case with smoke and mirrors, 2 types of bolstering evidence, prompt outcry testimony from the complainant herself, and the expert testimony regarding questionable sexual abuse theory. And counsel's most egregious errors relate to his failure to meaningfully challenge these types of bolstering evidence and show the jury just how weak the evidence was. So first, the prosecutor here made it seem like the complainant had told 4 different people in the years prior to initially reporting that she had suffered this abuse. But in fact, 2 of those people testified at trial and denied that they had ever been told about this outcry. The prosecutor did not call 2 other witnesses. And in the jury's eyes, that evidence would corroborate the complainant's report.
Counsel, I'm Justice Shulman. Do you hear me okay?
Yes.
Those 2 other witnesses, one so-called childhood acquaintances, one, they didn't have really much information to be able to reach out and find that witness. True?
That's correct, Your Honor. I'm primarily focused right now on Ms. Rodriguez, who was the adult. I'm sorry?
And the second one, I'm sorry, I don't mean to cut you off. And the second one pretty much was not going to be helpful.
Well, so that's the real question here. So yes, Ms. Rodriguez was not going to be helpful to the prosecution, but as far as the jury was concerned, they did not know that, right? The prosecutor explained that not in front of the jury at a sidebar, and so as far as the jury was concerned, this witness would corroborate the complainant's timely outcry. And in fact, it was the exact opposite. The prosecutor knew that this witness would not corroborate that evidence and, in fact, used that to defeat the request for a missing witness charge. So just to unpack that for a second, a witness with material information about the case who was available to the prosecution was essentially kept off the stand because her testimony would undercut the complainant's credibility rather than bolster that credibility. And the jury didn't know that. That's the exact reason for a missing witness charge, where one party suggests that there is evidence favorable to them. In fact, that evidence would be the opposite. And then that party fails to produce it. Then the jury is entitled in that situation, and should have been entitled here, to draw an adverse inference from the witnesses. absence.
This is Justice Weber. Why did the defense not call Ms. Rodriguez as a witness?
Well, it was not his obligation to do so, and I would just note that she was on the people's witness list before trial.
But
So,
the defense attorney was aware of Rodriguez's existence, one, and two, apparently Rodriguez lived in the building, still lived in the building. So I'm still curious as to, in terms of, at least in terms of a missing witness charge, the defense attorney had the opportunity to call Rodriguez as a witness as well. And you're stating that the defense attorney was told that Rodriguez would not be helpful to the people's case, and in fact would be helpful to the defense case. So again, Rodriguez was not called by the defense.
that's absolutely true. But the real problem here is that the prosecutor elicited testimony from their own star witness, suggesting that this other witness, Ms. Rodriguez, would corroborate a timely report of abuse and essentially put it in the jury's mind.
The testimony was simply that she had said something to Rodriguez, that she said something to Rodriguez.
That's correct.
Did she go into exactly what she told Rodriguez? She said she told about the abuse, a former babysitter, about abuse.
Correct. I mean, that's the exact point of eliciting the bolstering testimony, is to suggest to the jury that this is not a recent fabrication, and that in fact this was reported to someone outside the family prior to the reporting to the social worker. But the defense does not have that obligation, and the issue here is when counsel requests a charge that he is entitled to try and challenge this bolstering evidence that the prosecution elicited. The only reason that he was kept from getting that charge was because he did so in an untimely manner. He waited until after all the evidence was closed. And in fact, he did try to then bring this up in his summation. He tried to point out that the state did not call Ms. Rodriguez, and the judge sustained his objection, the DA's objection to that, and said that's pure speculation.
But that wasn't the reason that he didn't receive a missing witness charge. He wasn't entitled to a missing witness charge according to the court because, one, the witness was not under the control of the people. Two, the witness did not have testimony which would be favorable to the people. And counsel knew where the witness resided and that she was available. So the basis for the missing witness charge, according to the court, was sustained by the two things that I just mentioned.
Well, no, actually, the court did say that request was untimely. It did also reject it as being not favorable, which, again, I think the court was clearly focused on the wrong party when it comes to favorability. Again, the jury expected this witness would offer something that was favorable to the state. And so the evidence was favorable as far as the jury was concerned. That's the whole point of an adverse inference charge. Right. The court did also...
Excuse me, this is Judge Cappigan. Aren't you supposed to timely request that? So then if the other side says, you know what, maybe I should bring them in or have an opportunity to deal with it before the trial is over and you lost that opportunity to know why you were bringing the missing witness charge.
Yeah, that's exactly right, Judge. And the lawyer did have reason to believe they would call this witness, and she was on the witness list and mentioned during voir dire. But had he asked for this charge before the prosecution finished its case, they could have called her and put her on the stand. And in fact, they put another witness on, the complainant's brother, who also denied having heard an outcry. And Justice Weber, I'll just swing back and address the second part of your point. I mean, the judge did also deny the charge, saying that it was cumulative evidence to testimony offered by the complainant's mother and brother. But I think what's really important is neither of them said that the complainant did not report this to Ms. Rodriguez. There was no evidence in the state's case suggesting that outcry never happened. Had Ms. Rodriguez testified, yes, I was told about this, that would have been cumulative. But in fact, it was, as respondent argues now and as the state argued below, her testimony would have been the exact opposite.
Okay, and Mr. Bernstein, I've given you an extra couple minutes, so I'm going to ask you if you could wrap up so we could give you you'll have 2 minutes on rebuttal, okay?
Sure, thank you, Judge.
Okay, thank you very much. Ms. Morse? For the people?
Yes, Your Honor. Hopefully, Your Honor can hear me better at this point.
A little bit. You sound like you're in a tunnel, but okay.
Okay, sorry about that. May it please the court, my name is Deborah Morris, and I represent the people on this appeal. With respect to counsel, I would just note at the outset that this is a classic case where the court needs a 440 proceeding before deeming defense counsel, considering whether defense counsel's performance was deficient in any way, because on its face, the performance seems fine, and certainly defendant has not eliminated possible strategies that, on the contested issues, and eliminating those possible strategies is part of a defendant's burden. But to get directly to the missing witness issue, Your Honors have, as Your Honors have noted, I certainly agree with all that Your Honors have said. This was not bolstering testimony, as Your Honor noted. The people didn't suggest anything about what Rodriguez would have said. It was just that there was testimony by the victim that the victim reported the information, made an outcry, so to speak, to that person.
Yes, but the jury was certainly the jury believed, based upon the testimony elicited, that this was not recently fabricated, that there, at the time of the incident or shortly after the incident, she, the victim, had made these statements to Rodriguez. So the jury, at least from the testimony, would have thought that Rodriguez's testimony would have corroborated that of the victim. So this is already in their minds that she made the statement, she, the victim, made the statement to Rodriguez. And so now Rodriguez is not being called as a witness. And so they're not hearing from Rodriguez, and they don't know that Rodriguez would not have corroborated the victim. And in fact, Rodriguez would have controverted the victim.
You're absolutely right, Your Honor. I'm not sure that the jurors would have thought that, would have assumed that Rodriguez would have supported it since she was absent. But as Your Honors also pointed out, one is not necessarily entitled to a missing witness charge in any possible situation. There are requirements. One of the requirements is, in addition to timeliness, but one of the main requirements is that the witness must be under the party's control. And in this case, there certainly was not any evidence of that. So that is another factor. The judge made clear that timeliness alone was not the only reason to deny the missing witness charge. So even if counsel had complied with what defendant now says was a deficiency and had asked for the request in a timely fashion, defendant still would not have obtained the missing witness charge. The trial judge made that clear, because the witness was not under the people's control. In fact, as to one of them, the people didn't have, there was no indication even of the witness's last name or address. The victim had no contact in years. But, the main thing is also, as Your Honors pointed out, there was no reason to believe that this testimony would be consistent, with the people's position. And that's another one of the reasons. Not to mention the fact that this was one, in addition to everything else, this was one small point in a very large case where, unlike what defense counsel said, the proof was not thin. So not only would defendant not have received the missing witness charge if it had been requested, under the best of timely circumstances, but it could not possibly have made any impact, in the outcome. This was a case where the evidence was detailed and straightforward by the victim. There was difference. It was not just her account. There was also tremendous corroboration, very significant. There was a difference in her behavior both before and after the abuse began. She was raped for the first time when she was 9 years old. Her behavior changed dramatically at that point. I'm sorry, did I interrupt? You're on? Okay. There was an expert explained, the jurors could have understood, even just based on common sense, why the victim's reports were made later, but the expert also explained factors for a delayed outcry. The controlled call in itself, which showed the mother's reaction, showed that she already knew. It showed that the victim had made reports earlier. It corroborated that, you know, at a minimum. The mother was actually laughing at the ACS meeting, and that also corroborated the fact that she knew and that the victim had reported this. The victim testified, frankly, very credibly, that she reported her having been raped when she was 9 years old. She reported it when she was 10 years old. To her family members. Now, of course, she had the misfortune of having very unsympathetic family members. She then reported it to other official people when she was a little bit older, 13 or 14 years old. Any of the, all of the behavior, so-called misbehavior or so-called suspicious things that the victim did were completely consistent with having been raped on a regular basis for 2 years by her stepfather, beginning when she was age 9. So the fact that she then took up with other men and became pregnant, you know, at a very early age and became involved with drugs, all of those things were completely consistent with having been raped by her stepfather. And I would just say that defendant now, in his reply brief, refers to the victim as having had a history of having been manipulative towards a history of ensnaring and manipulating older men. That's on page 9 of his reply brief. I'm not sure how to even respond to that, but the notion that this girl at 9 years, having been raped beginning at 9 years old, can be characterized as someone who was manipulative and ensnaring older men, you know, is beyond the pale. There is absolutely nothing in this. I'm sorry.
I was just going to say, can you just finish it up, please, Ms. Morse? Thank you.
Okay. Well, if your honors have no other questions on those subjects, I guess that was those were the main arguments that I see defendants making at this point. So if your honors have no questions on other issues, we would rely on our brief for the remainder of the arguments.
Thank you.
The judge would be.
Thank you, Ms. Morse. Mr. Bernstein, you have 2 minutes.
Thank you. Just a few points. First of all, the respondent suggests that this should have been brought, that this ineffectiveness claim relating to the missing witness charge should have been brought in a 440 motion. There's absolutely no reason for that here. Counsel asked for the charge. He simply did so too late, and there's no dispute that he did so too late. And then he tried to bring it up in summation. He was not, you know, changing course in his strategy. He wanted to point this out to the jury. He simply failed in that application and failed as to the merits for the reasons that I've talked about. Now, my adversary talks about how this wasn't bolstering testimony because we don't know exactly what Ms. Rodriguez, the jury didn't know exactly what Ms. Rodriguez would testify to, but the exact reason for the prosecutor to elicit that was to put that question in the jury's minds and to suggest to the jury that this would be a witness who would corroborate the complainant. As far as
Mr. Bernstein, are you saying the jury knew that the prosecutor is planning to produce Ms. Rodriguez as a witness?
Well, she was on the witness list that was given to the jury during voir dire, so they had certainly had reason to believe that.
But they would have to have remembered that. And
sure. And again, I mean, the prosecutor put it in their minds that 4 different people had been told about this before the complainant reported to a social worker, and the state actually called one of those witnesses, Jonathan, and then he denied having heard this outcry. So it was reasonable for the jury at that point to expect that another one of these witnesses might be put on the stand.
Counsel, this is Justice Gonzalez. Nothing stopped you from finding the former babysitter, Ms. Rodriguez, who lived in the building where the victim lived.
I don't have anything in the record that talks about that. I mean, sure, the defense, I mean, there's obviously we don't place a burden on the defense in terms of producing witnesses, and the question here is the state's elicitation of this improper evidence and then kind of pulling the wool over the jury's eyes. So I don't see that really harms our argument. I would just to really quickly point out to respond to something that was said about the tremendous corroboration in this case. There was no corroboration, no evidentiary corroboration that did not come from the complainant or someone she told years after the fact when it was in her interest to do so. And the way that the only other corroboration that was brought in was an expert witness talking about a theory that has been rejected in many state courts and by many psychiatrists and psychologists, CSAAS. There was plenty available for counsel to research and investigate on Google and Westlaw to find ways to challenge this witness, and he did not do anything to that effect. And then just one other thing, I'm sorry.
Just to that point, again, there's no 440, so we don't know why counsel did not do that. We don't know what strategy counsel was employing in this.
Sure, I think the point is there could be no reasonable strategy because this witness was an expert who was offered to do exactly what Ms. Morse just did, which is repeat the allegations of the complainant and say that they are backed by science.
The strategy could have been because in summation, the attorney, went after the victim in terms of her past, in terms of her pregnancy, etc. So that could have been the strategy by showing that no expert testimony means anything based upon her past. But we don't know that because we don't have a 440.
I think, Judge, where an expert, jurors believe experts, where an expert is explaining and improperly explaining that the facts in the record and what she knows about the complainant effectively corroborates the complainant's credibility and tells the jury that this did in fact happen, that there's no reasonable strategic basis not to challenge that witness.
And do any of the judges have any further questions? Okay, thank you very much, Mr. Bernstein, both counsel, for your arguments.
Thank you.
And have a good afternoon. The next case for argument is Aberger versus Camp Loyalton.
Good afternoon, Your Honors. This is Mitch Frankel on behalf of Appellant.
Could you get a little closer to your mic, perhaps? Thank you.
Yes, I apologize.
That's better.
Can you hear me any better now?
I can.
Okay, good.
Thank you.
We believe the motion court erred in granting defendants respondent summary judgment application dismissing this case, as we believe there are several issues of fact. The court believed that the situation invited speculation, but we obviously disagree. We believe a jury could use its ordinary knowledge, intelligence, and experience in order to determine whether any of the conditions that were identified on the pathway when Mr. Aberger slipped and fell next to the embankment full of boulders was a foreseeably dangerous for a camp full of mentally and physically disabled campers.
Well, Counselor, was this particular plaintiff, was his disability more an emotional and a mental and a developmental disability more than a physical disability?
Yes, his was a mental disability. The camp was full of those who had mental disabilities, those who had physical disabilities, and then there was a combination thereof. Mr. Aberger was severely mentally disabled, 57 years old, and maybe he had, mentality of a 5-year-old or something along that nature. However, when the foreseeable danger isn't just for those who are on walkers or wheelchairs or on crutches, but those who can't appreciate the danger posed by this particular situation. They negligently placed a pathway behind the dining hall right next to a steep embankment full of boulders, large boulders. And this is all borne out in the photographs that have been authenticated and are part of the record.
Counsel, is it true that the camp had certain inspections and the inspectors did not give them any violations or indicate that there were any problems with the way that this particular walkway was situated behind the dining room?
That was indicated by the defendant respondents in their argument. However, just because they weren't cited with violations doesn't mean a dangerous and hazardous condition didn't exist under the circumstances. And just because there were, and even if there were no violations of any kind of code or rule of law or other regulation, again, is not determinative of whether or not a dangerous and hazardous condition exists.
Now, there was testimony by some of the people that worked at the camp that at night, because the temperature would drop, that the walkway could get a little dewy, D-E-W-Y, so that it would be a little bit wet, even if it hadn't rained or something.
That is correct. So they knew that was a situation where it could get a little slippery because it gets wet in the mountain air up in upstate New York when it's hot during the day and it's cool during the night. Now the slipping in and of itself is not alone the dangerous and hazardous condition. It's merely a precipitation. That was what precipitated the fall down the hill. There was no guardrail, there was no safety rail, and the lighting was atrocious. The lighting was just totally improper. They didn't have any fixed lighting fixtures on the outside of the building. This occurred at 9:15 at night. It was dark. And they're claiming that the light that shines through the dining hall, because if they leave the dining hall lights on, that and a small lighting fixture across a pathway some distance away, across a road some distance away, provided enough light.
So, counsel, this is Justice Weber. Excuse me. What in the record? What testimony was there that as to the lighting, that the lighting was improper, or that that you could not see?
Dennis Urquhart, who was the assistant, second in charge of operating the camp, and he's had a lot of experience running the camp and quality assurance and filling out accident reports and incident reports and investigations and so on. He testified that typically he was in his office when he heard through the walkie-talkie system that there was this incident, and his office was so close to the path and the hill where this occurred that he could typically see that area, but he couldn't do so on the night of the incident because he said, quote, it was dark. And that is, you can find out.
I thought that was, he was referencing where he saw the plaintiff, Robert. I thought that that's where he ultimately saw Robert and the Cesar, who was the camp counselor, who was with Robert at the time of the incident. I thought when he said it was dark, he was referring to where he ultimately found the two of them situated at the bottom of the embankment, for better one word.
Yeah, no, Your Honor, I believe Mr. Urquhart was saying, he was saying that in conjunction as to where he was in his office, that he could initially see. He was so close that he could see it, but he couldn't at the time because it was dark. Now, Nurse Dart, who also was on the scene within seconds of this occurring, or a minute and a half, according to her, and he was on the scene about 5 seconds from. Mr. Urquhart was on the scene about 5 seconds after hearing the walkie-talkie. It was Nurse Dart who said the area where she found Robert was dimly lit. But the area where that's the one I believe Your Honor may be referring to. Now,
because I thought that the nurse also stated that the pathway was fine, and she did not need a flashlight when she walked on the pathway because there were street lights as well as light coming from the dining hall. So I thought that was her testimony, that she didn't need any artificial light. She didn't need a flashlight because the path was fine. And
no, oh, sorry, Your Honor, I apologize.
Okay, ahead.
I believe she said that she didn't need a flashlight to get to Robert.
She said that she did not need a flashlight when she walked on the pathway because there were street lights as well as light coming from the dining hall.
Okay. Well, when she got to the area where Robert was located, which was mere feet from the pathway above, she said that area is where she found Robert. Again, feet from where he slipped above was dimly lit.
And then there was
also an indication.
There was also Savita Sharma, who's also an employee, and she also said that she didn't have any difficulty seeing Robert because the lights in the dining hall were on and provided illumination through the windows. She says there was also a light to the left of the pathway that provided illumination.
Ms. Sharma did say that.
So my question is, I just didn't see anything in the record that there was a lack of illumination on the pathway. And actually, when I saw testimony as to it was dark outside, I thought that was a reference to the fact that it was night because it was 9:15 at night.
Okay. Also, if Your Honor would take a look at the New York State Justice Center's investigation report, they interviewed various folks who were at the scene, either witnesses or at the scene. The only one witness that was identified was Caesar. And Caesar, they took a statement from him, and he said that he was with Robert Aberger in the dining hall. He saw him get up, run out the door. He said he followed after him right away because it was dark outside. And then he said he went ahead of Robert on the pathway so that he could be in a position to help Robert down the second set of stairs because it was dark. And I believe that there's and the photographs themselves that were taken at the inspection of this property, simulating the time when the incident occurred, also is enough for a jury to take a look at those photographs, listen to these deposition testimony, and decide was this proper light for this path that's right next to an unguarded hill for disabled people with filled with large boulders. I mean, they're walking on this, all times of day, including at night.
Okay,
how can somebody
Mr. Frankel, can you
the edge?
just ask you if you could finish up because you're given a little more time and you do have 2 minutes of rebuttal.
Okay. Okay. Thank you, Your Honor.
All right.
I believe that. Oh, should I finish now or?
If you haven't, yeah, go ahead. Just finish something up and then we'll go to the other side.
Okay. I believe, in summary on this, I believe there's enough in the record that creates an issue of fact. The photographs, the accident report, including the statement of Caesar, and the photographs, the accident report, and the deposition testimony to create an issue of fact for a jury to determine through their ordinary knowledge, experience, and intelligence as to was this an amalgamation of dangerous conditions and foreseeably dangerous for disabled physically and mentally at this camp.
Okay, thank you very much. You'll have 2 minutes in rebuttal. Can I hear from the respondent?
Thank you, Your Honor.
You're very welcome. Mr. Koplowitz?
Yes, may it please the court. The defendants cannot be held liable for the slip and fall accident because the plaintiff can't identify the cause of his fall without engaging in speculation. We talk about the evidence in the record. There's really sparse evidence in the record. I mean, there was no witnesses. Unfortunately for everyone, the plaintiff can't testify about what happened, and you only have these after the fact witnesses who came and responded and saw the injured plaintiff when he was halfway down the hill.
I want to say that in many accident cases, there isn't necessarily someone that was there that second, and witnesses come a minute or two later. I mean, there were several people there within a minute or so, as counsel indicated, as the record indicates, and they saw him lying down there, and Cesar was around there. So I'm not sure. I think that there were people that saw what happened. I mean, they didn't see exactly how he slipped, but he was walking along the pathway, and then he was, hit his head, fell down and hit his head on the boulder. So I think we could see, if you're not saying they're not positive if he misstepped or slipped exactly, okay, but I'm not sure if that is absolutely necessary under these circumstances.
Counsel, you mentioned the fact that the parties agree that the the plaintiff is unable to testify due to his disability. So would you say that the defendants owe that plaintiff an ordinary standard of care or a heightened standard of care given the disability that you just described? Or are you saying under these circumstances that because he doesn't have a physical disability, but rather a cognitive disability, that it doesn't make a difference and nothing special is owed?
With respect to, maintaining the premises, I don't believe so. I mean, as far as supervision, the testimony.
Sorry, you don't believe what?
That my client, that the defendants owed the plaintiff a heightened standard of care as far as, maintaining the premises. I mean, the premises had to be safe for an outdoor camp for anyone who was using it. I mean, there were people who were developing.
But this is a pathway by a slope that's has more of an decline or incline, as the case may be, than what the ADA would indicate is advisable for people who are disabled, who are developmentally disabled. How do you get around that?
Well, the ADA does not establish a standard of care for safety of pathways. I believe it's more of, access to buildings. But this plaintiff was not physically disabled. His mother submitted the application for him and said that he can walk independently on hilly and difficult terrain. So he didn't need help walking. He did not have a physical disability.
That's the admissions. That's the admissions form. That's the form that you use in order to apply to be at the camp. The form didn't say, and by the way, at nighttime, because of the area that we're in, all the grass gets wet at night and people can slip down a slope that's got boulders that are 4 foot by 6 foot wide.
I understand that, and that's why there was supervision there, and there was someone with him. But this is an outdoor camp that's designed to give these people, some leisure, a leisure activity. It's not going to be, there's tons of things that the defendants could have done to make the camp safer, right? They could put fences everywhere. They can say, you know what, there's no nighttime activities. Everyone go into their bunks, and at 5 o'clock when it gets dark, or 8 o'clock when it's the summer, it gets dark, you just stay in their bunk and don't do anything.
I don't understand that line of. I don't understand that line of analysis. You're saying that people should be grateful that they're allowed to go out at night. I don't know that you want to go down that.
No, I'm saying that of course it was dark. Of course it was nighttime at an outdoor sleepaway camp. There's going to be hazards when you're at an outdoor camp in upstate New York, and there's hills all over the camp. The thing is, was the camp reasonably safe? This pathway had been around. The plaintiff had been to the camp for 10 years before this accident, had never been involved in any prior accidents. There's no prior accidents on this pathway, no prior complaints about the pathway. The camp was.
Don't you think that a jury should be able to determine what the plaintiff's abilities really were? What his cognitive abilities really were?
Well, I don't.
As far as being able to determine, being able to negotiate any of this?
I don't think so. I don't really think that argument is made anywhere.
Well, counsel, let me put it another way. In this instance, we're talking about an individual who had no physical limitations, according to the record. Did you owe a heightened duty to other individuals in the camp who may have had a physical disability and may not have been able to maneuver along this pathway, given the fact that there are no guardrails or any railing which would separate the path from this decline?
I mean, possibly, if the testimony was there were some campers who required, one-to-one supervision, that there needed to be someone with them at all times. Possibly if that, I think there was a heightened duty as far as supervision. As far as maintaining the camp, that goes hand in hand. I mean, if someone had it could not be left alone and walk by himself because or for some other reason, then yeah, I mean, we owed a heightened duty to be with that person and make sure that they're safe. Here, there was a counselor with the plaintiff. This was not a physically disabled individual, and this was a high-functioning individual. I mean, it's not like he was nonverbal. He, all the testimony was he had conversations with everyone. He was very friendly. He spoke to everyone. How are you doing? I'm doing fine. This was a high functioning disabled individual. And we had a counselor with him. It was a slip and fall on wet grass. I mean, I don't think that, any heightened duty of care would have prevented this accident.
Is there anything that you, Mr. Cobbles, is there anything that you could comment about the lighting situation there? I mean, what was in the record about it being dark? I mean, is it clear that the reference was to it was just dark outside, or that the path was dark, or the stairs were dark, or what were they talking about?
I think it's two things. One, generally it was dark because it was at night and it's a sleepaway
I got
camp.
that.
Yes, they're outside. So of course, just like when you drive at night, it's dark. You have lights so you can see. There were lights around the camp. There were lights on the windows. It was also dark where the plaintiff's body came to rest because that was further away from the dining hall. The path the windows are right alongside of it. The windows that have the light on 24/7 shine through the windows and provide light onto the pathway. The nurse testified, came down the stairs, walked down the pathway, had no issues, seeing where she was going. The other individual, Urquhart, was looking at the area where everyone was, and he said that area was dark. And yes, I'm sure that area was dark because it was further away from the light. I don't think there's any testimony that either in the accident report or the Justice Center report, which I don't even believe is admissible, just along with the photos that were taken years after. But there was no testimony that the plaintiff had difficulty watching where he was going. It's not like he missed a step or he stepped somewhere where he shouldn't. The pathway just happened to be wet because it's nighttime upstate New York. When the temperature changes, then it can get wet.
All right. Is there anything else that you want to address? Do any of my colleagues have any further questions? Okay, so
if there was just one thing I could address. Well,
yes.
I don't know if I'm out of time.
Yeah, you are out of time, but I'll give you 30 seconds.
I mean, just the fact that it's generally dark, there's case law, nightclubs are dark. There's tons of areas where accidents occur where it's dark, where that's not a proximate cause of the accident. This ACA accreditation, these inspections that Your Honor asked about earlier, they're important. The ACA, as far as plaintiff's expert, we really haven't spoken about that, but that's the standard. I mean, to be accredited by that entity is a big deal to camps. Parents, it's important to them that this camp is accredited by the ACA. They inspected this whole area. They knew there were developmentally disabled and physically disabled campers there, and there were no violations issued, and they were accredited. I think a jury is going to have to speculate as to far as what exactly caused this accident, other than a misstep on wet grass, which is not an actionable dangerous condition.
Okay, thank you. Thank you very much. Mr. Frankel, you have 2 minutes. Mr. Frankel?
Sorry, Your Honor, I had it on mute. Sorry, I apologize. Well, first, I believe causes of the incident, one or more, can be certainly identified without speculation due to circumstantial as well as common knowledge. There are facts and circumstances here where a jury can draw from their ordinary knowledge, experience, and intelligence, and make a permissible inference as to what happened and how it happened. There were no railings to restrain Mr. Aberger when he slipped and fell, when he obviously was walking too close to the edge, which he, a railing not only restrains, but it also delineates the edge of this pathway that is right next to a drop, this steep embankment with boulders. So that wasn't there, and that didn't delineate it. My colleague makes reference to that heightened duty is maybe due for supervision, but not for keeping the camp safe and making sure that any dangerous and hazardous conditions don't exist. I believe that knowing that you have severely disabled, physically and mentally disabled campers there, would be a
Counsel, would you address the issue of the ACA inspection? Is the fact that the campground passed inspection dispositive here?
Not at all. Not at all. I mean, this court has found, as well as other appellate courts, that simply there being no violation of any code or ordinance is not dispositive on whether or not there was a dangerous or hazardous condition or whether negligence existed. It's merely some evidence. I'm sorry, it's not dispositive. So the fact that they may have passed an ACA inspection does not mean that this camp was safe for Mr. Aberger as well as any of the other campers, physically or mentally disabled. As your honors have pointed out, that
does anybody have any further questions for Mr. Frankel? All right, I think we're going to have to cut the time now. We have your briefs and we will take a look at the issues that you've raised. I thank both of you very much for the arguments this afternoon.
Your Honor has the reply brief as well, right?
Oh, thank you.
Thank you, Your Honor.
The next case that's on for argument is Romano versus One City. Mr. Popkin for the appellant.
Good afternoon, Your Honors. Eric Popkin on behalf of the plaintiff appellant. Can everybody hear me?
Yep.
Okay, thank you, judges. Good afternoon. On behalf of the plaintiff appellant, Mr. Romano, based on the facts of this case, was entitled and is entitled to summary judgment under labor law section 240, open paren, close paren 1. The facts are simple. He was working at elevation. He was subjected to the dangers of gravity. He was working on an unsecured and improper ladder. That ladder shifted and moved. That caused him to lose his feet to slip and to fall to the ground below.
What are we to do about the accident report that was filled out by his foreman shortly, Mr. Collins, shortly after the accident, that says that Mr. Romano slipped as he was descending off of the ladder?
Right.
What do we do about that?
Your Honor, unfortunately, the court below focused on Ellerby versus the Port Authority, and when the court should have, and this court should really be directed to Wozlanowski versus the Museum of Modern Art, Tozzolino versus Consolidated Edison, and Marino versus Continental Tower Condominium. That issue has been addressed by this court on so many different occasions that's very clear that the statement by Mr. Romano in and of itself does not contradict the causation of this accident. The defendant needed to do more here, and they have not. Mr. Collins, at the time he took his reports, confirms everything about this case, but never asked Mr. Romano why his feet slipped. Now, what distinguishes this case from Ellerby is that fact itself. Mr. Romano has stated from the very get-go that he was caused to slip off this ladder because it moved, because it was unsecured. In Ellerby, which the court relied on, there's a second part to the equation which is missing from this case. That second part to the equation is that there is evidence from someone else that attacks causation. Just simply saying that you slipped does not attack causation without more. That's what those three cases that I have cited stand for. In Ellerby, the person who would have been Mr. Collins' counterpart, Mr. Jackson, went to the location and inspected the ladder immediately after the fall. Now, Mr. Collins didn't do that here because he couldn't, because the ladder had already been picked up and moved from where the fall occurred. So Mr. Collins, knowing that, should have asked what caused your feet to slip, but he did not. Mr. Jackson, on the other hand, looked at the ladder and it was secured in two places. That's not the facts of this case. And that's why relying on Ellerby was inappropriate and why the other cases are. This court has said on at least three different occasions that where the plaintiff says he slipped, that doesn't create any conflict in his testimony. There has to be something else. And that's what's missing here. The defendants would like you to speculate as to why this slip took place, but that's not appropriate. There has to be some evidence to show a different pattern of how the accident happened. And quite simply, that's just not the case here. Mr. Collins didn't inspect, he didn't check. He then later on comes up with an affidavit that is contradictory to his prior deposition testimony, which the court below properly ignored. What the court below did correctly was find that Mr. Romano had made out his prima facie case. And I don't think that anybody disputes that. What the court did incorrectly from our point of view is a misapplication of the law. There has to be something in admissible form before the court, once that prima facie entitlement is made, that contradicts or creates a question of fact. The law in the First Department is the mere statement by someone that he slipped without more does not contradict how the accident happened. It doesn't create an issue of causation. There is no second theory of how the accident happened. In Ellerby, Jackson's testimony creates, because he found that it was secured, creates a question of fact. And also in Ellerby, and I hope this is answering Your Honor's question on this area, also in Ellerby, the plaintiff stated that he had lost his footing, but there's now a second theory of how the case happened. And that's why in Ellerby a question of fact was created, and why no question of fact is created here. The defendant would like this court to speculate, and that's not a basis. Once the plaintiff has made out his position and done so properly through admissible evidence, speculation cannot defeat the motion. You know, you're in the papers submitted to the court by the defendant, they want you to think that this ladder was wedged in place so it couldn't move. But that's not the testimony. There was a 6-inch clearance. This ladder was the wrong type of ladder. Only 2 of its feet were on the ground. There was no securing done to the ladder itself. There was no individual assigned to help Mr. Romano to secure the ladder. That's why the court was correct in finding that the prima facie case had been made.
Okay. Do any of my colleagues have any further questions for Mr. Popkin? Okay, I think that was that's like the issue in this case. So
I believe you're correct, Your Honor. That is the one issue, and based on the law of this department.
Thank you.
The defendant hasn't shown a question of fact. Thank you, Your Honors.
Thank you very much. Ms. Lawless for the defendant respondent.
Yes, Your Honors, thank you. May it please the court. You know, in this case, there are 3 theories on how this accident occurred. There are Mr. Romano's statements to his site supervisor, Mr. Collins, which Mr. Collins reported at deposition, where when asked about how this occurrence happened, he said he was coming down off the ladder and slipped on the last step and fell on the floor. And that's consistent with the incident report.
Okay, go ahead. Go ahead.
Yes, and that's consistent with the incident report that Mr. Collins filled out that same day that repeatedly says he slipped off the ladder, he slipped coming down the ladder, when coming down the ladder, he slipped off the step. This is completely inconsistent with Mr. Romano's later deposition testimony. When asked how this happened, he said the ladder fell out from under him and he fell backwards. He said that numerous times, that the ladder moved backwards and he fell backwards. He follows this up later with an affidavit where he says that when he was on the ladder in the course of performing the work on the 4th step, that the bottom of the ladder shifted and slid to the right of the floor, and he and the ladder then fell and toppled over to the left. So there are 3 very different accounts of how this occurred. And the recitation to Mr. Collins right after this incident happened, 5 to 10 minutes after it happened, is not a prima facie labor law violation, because there was no, in those initial statements, there was nothing to say that he never said the ladder moved, the ladder shifted, the ladder fell.
Didn't you have an obligation to provide Mr. Romano with a ladder that was steady and sturdy and from which he wouldn't fall, and whether he slipped as he was coming down or he was using his work and it moved around? I mean, aren't you responsible under any of those scenarios?
Well, yes, I think an employer does have that responsibility to provide that safe device when there is elevated work being done. But in this case, there's no evidence that that device in the course of the work being done was not safe. There's disputed testimony, 3 different accounts of exactly what happened in this case. The first account, there's no indication that the ladder moved at all. The ladder was completely stationary at the time. Mr. Romano said to his supervisor, Mr. Collins, as he was coming off the ladder, that bottom step, his foot slipped as he was getting off on that bottom step. There's no indication that the ladder moved, that it was insecure. The record evidence shows that it was wedged between an commercial air conditioning unit and a wall that was only about 18 inches apart. It was, again, very difficult for this ladder to move. And the plaintiff in this case thereafter proved two different state of events in terms of how exactly this ladder moved and how his body moved. So our only point here is that there is indeed questions of fact that should not be decided at the summary judgment stage. There's too much inconsistency here in terms of the course of the events.
Do any of my colleagues have any further questions? Okay, well then, thank you both very much. We'll certainly take a look at those cases.
Thank you.
Have a very nice afternoon.
Stay safe.
Thank you.
Thank you.
All right. What? Okay. The next case for argument is 3P-733 versus Davis. We have the appellant first.
Good afternoon, Your Honor. May it please the court. Very basically, this is simply a case, and with all due respect to the lower court, fraud was adequately pled. Could the pleading have been, cleaned up a little bit better? Of course, but
let me. Wasn't it really? Weren't the facts and the ultimate relief that you sought the same as the facts and the ultimate relief that you sought in the contract cause of action, which is still in this case, so that it's really duplicative, which happens in so many of these commercial cases?
Well, Your Honor, I understand that argument, and I think that it's far too early in the stage of this litigation to make that conclusion. But what I do think, though, I understand my adversary is attempting to make the what's called the so-called economic loss doctrine. The difference between a fraud claim and the economic loss doctrine, which I am saying is not present here, is that with the fraud claim, the difference is if you enter into a contract with mere insincerity, and first of all, we're not even sure there was a contract for the Steinbridge Group, but the point is, if you enter into a contract with mere insincerity and there are no other damages, then yes, it's a breach of contract claim. But if there is no contract, and it's far more than mere insincerity, which I think we've proven in spades with with the roughly 800 pages of affidavits I believe we've submitted. I think that we've adequately proven that Mr. Bardwaj entered into the contract with far more, Mr. Davis was far more than simply insincere. So, and his behavior, Mr. Davis's behavior afterwards, is very demonstrative of that. He kicked Mr. Bardwaj out summarily, and then he denied that Mr. Bardwaj had anything to do whatsoever with the Steinbridge Group, even though it's clear from the documents that we attached to my client's affidavits that the Steinbridge Group, that my client was in fact a partner of the Steinbridge Group. There's ample evidence for a jury to draw that conclusion. So again, the difference between the contract claim and the fraud claim is that we're not really even sure there was a contract. I don't believe there is. Secondly, it's far more than mere insincerity, and that's very, very far. That's very much demonstrated by Mr. Davis.
Would you address your defamation claim and the letter that was sent to Mr. Bauer at Real Capital?
Sure, and Your Honor, I would just say that I think that we, as Your Honor may be aware, there's a concurrent litigation in New Jersey. We just had a proof hearing, because the other side defaulted on discovery, so an inquest in New York parlance, I would say. So, so that was relatively addressed in New Jersey. But I would say that the litigation privilege, you have to have more than something merely arising out of litigation. It must be, the communication must be made in the context of litigation. And here what we had was Mr. Davis sending a letter to somebody in Colorado about a New Jersey litigation when that person in Colorado had absolutely nothing to do with the litigation. And as we argued recently before the New Jersey court, it was done out of sheer malice. And New Jersey we were entitled to that inference because of the defaults, and we were, as noted, instead of a trial, we were at what we call here an inquest. But it must be something more than it must be, the communication must be in the context pertinent to that litigation, and that's Front versus Cahill 24 NY 3D 713. So that's all I would say to that, and we are still waiting on a ruling, which I believe.
Let's not keep referring
Sure.
to the New Jersey case, because that's very nice, but we're only concerned about the record in our case that was before Judge Maisley. So,
of course.
So that's why you think that the defamation case should come in, because Mr. Bauer, I think, was sent the letter by Mr. Davis, and allegedly, there was documentation to show that what was indicated in that letter was not true in terms of his embezzling money. Correct?
Correct, Your Honor, and it was also the litigation privilege that my adversary argues simply does not apply, because it was not made in the context pertinent to that litigation. If Your Honors would let me, though, I would like to go to address the fraud claim slightly more, if that's permissible.
You got 2 more minutes, so go ahead. Is that okay? Yeah.
Sure. I mean, I would simply like to say that under. My impression of Justice Maisley's opinion was that we simply were not granted all favorable inferences. But again, with respect to the economic loss doctrine, and if Your Honors simply review the affidavits, there is ample evidence to show that. And again, the requirements that the differentiation. And I just like to cite a case. The differentiation is Fairway Prime Estate Management versus First American International Bank. That's 99 AD 3D. 554, and that's what explains the so-called economic loss doctrine, where a fraud claim may be subsumed in a contract claim. But there, you actually have to have a contract. There has to be more than mere insincerity, and there other damages are available. And clearly, with all due respect, if Your Honors read the affidavits, you'll see that other damages are clearly warranted here. Punitive, specifically, based on the conduct. And again, Mr. Davis's conduct afterwards, after he kicked my client out, is clearly denying that my client had anything to do, had any partnership with Steinbridge. That in itself shows his intent going forward. He led my client on and saying, yes, we'll eventually sign an operating agreement. But then all of a sudden he can't even get in. He's kicked out of the company. And then Mr. Davis denies he was ever a partner. So,
okay, I think we got your points on those issues, and we will certainly take a look at those cases and things that you cite.
One moment for conversion. The conversion.
Just 30 seconds, because
that's all I need. That's all I need in the case of Front versus Cahill. That's 24 NY 3D 713. Forgive me. That's on
the defamation you mentioned.
Forgive me. I'm talking about Quittel versus Kellner, 264 NY 32. A corporate officer can be liable for conversion of corporate funds, and the lower court, with all due respect to it, relied on a second department case that said that conversion only applies to chattels.
Okay, we will take a look at all of those.
I will rely on either arguments for. Thank you.
Mr. Morris, for the respondent, you also have 6 minutes.
Thank you, Your Honor. Can you hear me?
Yes.
Great, thank you. So the trial court below correctly dismissed the fraud case. This is plaintiff's fraud case from record page 6, that my clients materially misrepresented to Bardwaj that the Carbine agreement would carry over to Steinbridge word for word, but we ousted Bardwaj from the joint venture under the false pretext of petty theft. That is the fraud claim. And it's the same for breach of contract. At oral argument, Mr. Warner was asked, what is your oral contract? What is the alleged breach? This is at page 47, line 15. And Mr. Warner answered the court at page 47, line 18. And he said, by shutting my client out of the company on false allegations of theft, and thereby not permitting him to benefit from any further distributions from that particular LLC. That's the breach of contract here. And Mr. Warner continued at page 47, line 25. Okay, because again, we maintain that he was pushed out on disprovable pretext. So the fraud claim here is exactly the same as their breach of oral contract claim, and the trial court was correct to dismiss it as duplicative. Now, with respect to the defamation claim, Your Honor, on August 22nd, 2017, counsel for CPG Invest sent the letter to plaintiff Bardwaj, documenting his malfeasance and expelling him and 3P as a member of CPG. When the New Jersey action was filed 7 days later, counsel for CPG Invest appended a copy of that lawyer's default letter to the New Jersey complaint. A copy of the default letter was also then provided to Mr. Bauer of Real Capital Solutions. Now, the lawyer's default
what
letter—
did Mr. Bauer have to do with the New Jersey litigation? He had nothing to do with it. He was a potential investor, from what I understood, in the company. Why should he have to have gotten that August 22nd letter?
No, there is no allegation that he was involved in the New Jersey action. However, the question is whether or not the letter itself is covered by the litigation privilege. And the litigation privilege attached to the New Jersey default letter, because it was drafted in the context of a good faith litigation. Now, my colleague on the other side—
Aren't you mixing apples and oranges, counsel?
No, Your Honor. If you look at, although obviously not binding, the Second Circuit Tacopina case, the question is not whether the recipient of the letter was involved in the action. In that case, it was provided to the Daily News. It was published to the entire world. The question isn't whether or not—
We're not talking about that. We're talking about a letter that's included as part of a litigation. No problem. In New Jersey, no problem. But then Mr. Bauer has nothing to do with this event, litigation, activity, conduct. Why would he get a copy of such a letter if not for malicious purpose?
Well, I don't want to sort of speculate as to the malicious purpose. Obviously, that goes beyond the record in this case, although there were good reasons to send him this letter. But that being said, the question before the court is whether or not the letter itself is covered by the litigation privilege. Once that question is answered in the affirmative, you're allowed to take that privileged letter and publish it to the entire world, such as the Daily News, as the court found in Tacopina. It's a binary question. Is the letter privileged or not? Now, going to the question of how this was addressed in the trial court, my colleague didn't brief or argue the litigation privilege issue in the first place, and thus Justice Maisley properly found that that prong of the defamation claim is deemed abandoned. That's page 9 of the record. So attempting to now argue the litigation privilege question here in the appellate court is an impermissible second bite of the apple. Nor does my colleague's argument that the New Jersey action was some sort of a sham litigation hold any water, because the record itself, as put there by Mr. Warner, says that the New Jersey action is close to being litigated to conclusion. So clearly the New Jersey action is not a sham litigation. So once you find the letter itself is privileged under the litigation privilege, whether or not you give it to Mr. Bauer or whether or not you publish it to the Daily News, it is still privileged under defamation law. Finally, I'll briefly address the conversion claim. Now, plaintiff's appeal on the conversion claim should obviously be dismissed as well. In their complaint, they say that the conversion claim is not limited to the business interest, but also the monetary interest that exists in the business. But this is not a chattel or a thing that can be the subject of a conversion claim. The subject matter of a conversion claim must be an identifiable, tangible personal property, and cash doesn't cut it. Now, my colleague—
I'm sorry, Mr. Morris, this is Judge Schulman. Isn't the Carver bank account a discrete corporate asset that could be deemed to be converted?
Well, you have to ask whose asset it is, Your Honor. So Piyush Bardwaj, the plaintiff in this case, is the 100% owner of 3P, an LLC. 3P, an LLC, is the 40% owner of CPG, Carbine Property Group. Carbine Property Group had a bank account. Part of the breach of contract claim is that Mr. Davis improperly kept the money from CPG. However, nothing was taken from 3P, the plaintiff, who's just a 40% owner of this other corporate entity, which happens to have a bank account, nor was anything taken from Mr. Bardwaj, who is the 100% owner of 3P. So whether or not a bank account might be an identifiable chattel is beside the point, because it was not owned by either 3P or Mr. Bardwaj. So a conversion claim can't be thus stated derivatively through two levels of ownership.
Okay, does anyone have any further questions?
Your Honors?
You don't have any, you each got 6 minutes. You were a little late in making your request. I gave each side 6 minutes. So we will take a look at all the things that you've said and whatever else is in the record, which we've mostly looked at also, but we'll look at it again. And thank you both very much for the arguments.
I was hoping to respectfully request.
Thank you very much.
Thank you.
Have a nice
Your
day.
Honor, sorry about the technical glitch there.
No problem. The next case that's being argued is People versus Gary Joseph.
Good afternoon.
Appellate.
Good afternoon, Your Honor. It's David Clem for Appellant Gary Joseph. Reducing Mr. Joseph's sentence would, as the court below stated, be the fair thing to do. The prosecution's action here in increasing the sentence is, as the court below stated, it didn't make sense and was very unfair. The court below
Actually, didn't Judge Neubauer at plea and sentence say that she was totally disgusted?
Yes, she was totally disgusted, and she was right to be totally disgusted by it. There was no rational reason for increasing the offer from 3 years plus 3 years of post-release supervision to 5 plus 5 years without warning and, frankly, with no explanation when called upon for it. The one explanation they gave was demonstrably false, which was that it was a pre-indictment offer. In fact, the offer was made 8 months after indictment. Defense counsel merely said that he wanted some time to speak with Gary Joseph about some of the discovery material, because this was, again, as the court below recognized, a very weak case in that there had been a negative identification from the eyewitness. That was the reason. It's really bad practice to withdraw an offer without affording that opportunity and without notice. In fact, since then, the legislature has specifically outlawed it, saying you can't have this exact type of exploding offer. There's good reasons why the legislature made that. While it wasn't illegal at the time here, this court now has the opportunity to correct this, and that's what we're asking the court to do. While unfortunately we can't give Mr. Joseph the same offer that was made, the minimum's 3.5 years, not 3. I believe that minimum of 3.5 years would be appropriate here, as well as a reduction in the term of post-release supervision to comport with what the original offer was here. Unless the court has any questions about it, I would suggest this is also an appropriate individual in which to do this to. He's a first felony offender, had some employment history, and it is the appropriate thing to do and the fair thing to do. Thank you, Your Honors.
Thank you, Mr. Clem. You'll have 1 minute in case you want for rebuttal. May I hear from the District Attorney's Office, please?
Good afternoon, and may it please the court. Ryan Fuller.
Good afternoon.
There is absolutely no reason for this court to modify the defendant's negotiated sentence, and every reason for the court to affirm, as this court is aware
so
from
the question is, what changed in 3 months? So he's made the offer. The initial offer is made, I assume, to the I guess to the either the attempt rob 2 or to the rob 2, whatever, with 3 years and 3 years post-release supervision. And so then 3 months later now, the offer is 5 years with 5 years post-release supervision. So what changed within that 3 month period of time?
So, Justice Weber, I think just to back up a bit, page 14 of our brief, footnote 11, outlines the timeline here pretty clearly. This was a pre-indictment offer. It was made in June 2017. It was held open for more than 11 months. The defense dragged their feet, and the people changed their offer. And by the way, they only increased it marginally from 3 years to 5 years, which is an incredibly low sentence for a C violent felony. Had defendant gone to trial, he would have been facing a B violent felony. He would have faced a minimum of 5 years. Yeah, 25 if convicted of the max.
25 is the max. But you say that the defense dragged their feet. They characterize it, and what the record reflects is that defense counsel said that he didn't have an opportunity to review the discovery material. So why, if the offer is made of 3 and 3, why should not the defendant be given the opportunity to review the discovery materials, the police reports, etc., to make an informed determination as to whether or not he wishes to accept the plea or reject the plea offer?
And that's just it, Your Honor. The defendant did have an ample opportunity to review the discovery. The defendant received full discovery in January of 2018, as reflected in the record. Defense counsel averred on the record a month later that she had received, quote, a lot of discovery, but could not conclusively say she had received it all. It wasn't until May 2018 that the offer changed. So in that time, defense, again, dragged their feet. They could have reviewed the discovery. At a minimum, they could have said, we haven't reviewed all of it. Can you please leave the offer open? But again, this offer, by the time it changed, it had been open for 11 months. And we moved it up marginally.
So the defendant is being penalized because the defense attorney did not say, could you please leave the offer open?
The defendant is not being penalized, Your Honor. The defendant received a very fair sentence of 5 years, which is, again, it's the minimum had he gone to trial and faced the B violent felony. It's a gunpoint robbery. The defendant had, again, ample opportunity. But as this was moving closer to trial, and by the way, the defendant could have elected to go to trial. You know, in his brief, he continues to say that the prosecution's case was weak. But in May 2018, when the renewed offer, or the revised offer rather, was made, he still waited 3 months to decide whether to take it or not. In those 3 months, in August 2018, again, he could have decided to go on to go to trial if the prosecution's case was as weak as he thought. He didn't. He accepted the offer with full knowledge of the consequences, and it would be unfair toward the people to basically retrade on that now on appeal, not to mention the policy it would set for defendants that are unhappy with their offers just to come back later and try to say that the prosecution was unfair. Again, there's no reason for this court to modify this fair sentence of 5 years. If Your Honors have no further questions, we will rest on our brief.
Thank you, Mr. Foley. Mr. Clem, you have a minute if you want to say anything.
Sure. Of course, it's not just the defense here that's saying it's unfair. It was the court overseeing this very proceeding. And again, it was the court who said, and I'll quote, "It's not the strongest of cases." Let me also just throw in one last quote, which is from the February 6th, 2018 proceedings. Defense counsel said that it doesn't mean we may not be interested in an offer in the future. It's just that we need more time, and I have to go over discovery with them. Clearly, defense counsel believed that the offer was still on the table. The prosecution never said anything there to suggest otherwise. That was the opportunity for the prosecution to say, no, you need to take it now or it's forever off the table. That certainly wasn't done. It would not be allowed today. And we think there's every reason in the world why reducing Mr. Joseph's sentence to a term of 3.5 years would be appropriate. Thank you, Your Honors.
Thank you very much. Thank you both. Have a nice afternoon. The next case for argument is Amorim versus Metropolitan Club. The plaintiffs, appellants, I guess cross respondents have 5 minutes. Each side has five minutes. So Mr. Fettner.
Good afternoon, Your Honors. May it please the court. My name is Michael Fettner, and I represent the plaintiffs, appellants, cross respondents in this matter, which comes up to the court by cross motion of summary judgment on 2 actions that were consolidated below, one called Amorim and the other called.
Sir, it's hard to hear you.
Yeah, there's a feedback, do you have two items on two different
devices?
Like devices, because we're getting a lot of feedback. No?
No. I know in the adjoining office, somebody might be watching the webcast. Would that cause that? It's not in this office.
All right. Well. All right. Go ahead.
I apologize for that, Your Honor. I had checked it before, and everything seemed to be working fine. This case involves Labor Department, or labor law, and Labor Department regulations involving the hospitality industry, and specifically concerning what are called administrative surcharges. And the plaintiffs were banquet servers who.
Yeah, I think we're familiar with the facts. So just
Yes,
so
Your
why
Honor.
don't you just get onto the points that are most important to your client's position?
Yes, Your Honor. I guess I would like to focus on the because it hasn't really been addressed in other cases. We'd like to focus on the dispositive nature of the font size. The regulations use the word shall, that the notification shall include a statement, shall use ordinary language, and shall appear in a font size similar to surrounding text, but no smaller than a 12-point font.
So it seems like it was the same as the surrounding text, but everything was looked like it could have been in smaller than 12 font, and I think that's your claim, right?
Yes, Your Honor, that is our claim. The rule, it's 12-point is the rule, but 7-point is minuscule. We actually went to the trouble of hiring an expert in typography and graphic design, and as we put in our papers, using one measurement, she came up with 7 points, and another, using the Shadler precision rule, she came up with 6.7753. So we're not talking about anything that's close to 12-point. We're having a substantial deviation from the dispositive requirement, and the trial judge found that the club failed to comply with subsection 3 of the regulation by utilizing a font smaller than 12-point.
But she found it didn't matter anyway?
She found that it didn't matter anyway, and she kind of ignored our argument that based on ample case law, including the twin cases from the 1980 Court of Appeals, that where there's a requirement to have a certain size in a document, a certain font size, non-compliance ends the matter. There's a finding against the party that was required to, and this has occurs in the banking industry, in insurance industry, in property industry, in vehicle. So it applies across the board. And we cited, I think the language, if I may, Your Honor, we cited a 1983 Second Circuit case, but where it enforced a requirement of notice in 10-point font size and rejected the argument that the 8-point type size was otherwise adequate. Quote, the 10-point guideline is a clear one and quite easy to follow. And that was read to preclude.
Do you want to address also the something that they're appealing was that the court granted you class certification, consolidated these cases and granted you class certification at least on part of this. And I know that he's appealing that. Do you want to address that? Because that's an important issue too.
Yes, Your Honor. This court should affirm the trial judge's class certification. That we cited any number of cases in our brief where in these kinds of cases, labor law cases, where there may be some individualization of damages, that trial courts have no problem deciding damages in the class situations. The class here is approximately 500 former employees, give or take, and it's a certainly manageable class. And Article 9 gives the trial court full discretion to how to figure these things out. And I would even suggest this is a garden variety class action in this setting. And the trial judge correctly distinguished the Walmart case as the basis for so that part of the decision should be.
Okay. Do any of my colleagues have any specific questions to address to Mr. Fettner? Okay, well, I think we were familiar with all the issues that were raised. I thought those were probably two biggest issues. So could I hear from that? Thank you very much. Could I hear from Mr. Robb? I think that's the right person. I see you waiting there.
Thank you, Your Honor, and may it please the court. I'd like to focus primarily on the points that Mr. Fettner raised. And before I do so, I would just like to highlight the salient facts, which are these. The banquet contract at issue clearly and unambiguously, as the court below found, explains that the surcharge in question, and I'll read it, is not a gratuity, will not be distributed to club employees, and is subject to sales tax. And there is no record evidence to suggest that this club, this defendant, ever made a contrary statement to any guest, to any patron, not in writing, not orally, nothing. The record evidence is entirely consistent in terms of how the club explains the surcharge. It explains.
But I understand that argument, but didn't you also have an obligation to follow the statute that requires that this be stated in 12 font? I mean, wasn't that part of it in order to take advantage of the safe harbor? Didn't you have to do that too?
Not at all, Your Honor. And let me just back up a second to put it, and it's a regulation. It's not a statute, but let me put it in context.
Sorry.
So we start with the statute. The statute is Labor Law 196D, which says that an employer may not retain gratuities or charges that purport to be gratuities. Right? That's the statute. That's the baseline. That's where we begin the analysis.
Okay.
Then we have the World Yacht case that says, okay, what is a charge that purports to be a gratuity? A charge that purports to be a gratuity, according to the Court of Appeals, is something that a reasonable customer would believe is a gratuity. So that if you give it a vague or ambiguous term like a service charge and you don't amplify it with an explanation, that could be something that is a charge that purports to be a gratuity. Or if you have a disclaimer on page 1 of the document and then you've got some inconsistent explanation of the charge elsewhere in the banquet documents, that could be a charge that purports to be a gratuity under World Yacht. We have none of that. Now we have this regulation, which of course is preceded by Department of Labor guidance that says, look, how do we determine what a reasonable customer would believe? We look at the totality of the circumstances. And that's what the Department of Labor said. And then this regulation comes out, 146 2.19. And for reasons we explain in our brief, we believe that statute or that regulation, it's not the model of clarity, but we believe that it is not mandatory, but rather it is illustrative. And where I'd really like to focus, and we offer several reasons to support that conclusion, where I'd really like to focus for purposes of this discussion is this court's decision in the case of Ahmed against Morgan's Hotel Group. And if I recall correctly, Justice Kapnick and Justice Weber, I believe you were both on the panel that decided that case.
Correct.
In that case, we had a number of things going on. First, we had the plaintiff making the argument that, well, wait a second, you have a contract that has a disclaimer, but the disclaimer doesn't appear elsewhere in the banquet documents. And this court said, no, that doesn't matter. if the disclaimer is clear and unambiguous, World Yacht is satisfied, and the fact that you didn't put the disclaimer on each and every page of the document is not dispositive. What does that have to do with this case? Well, the very regulation that plaintiffs are relying upon, 219 sub C, says that adequate notification shall include, and we believe that that shall include piece of it is what makes it illustrative, not mandatory. But it goes on to say that the adequate notification will include a statement in the contract with the customer and on any menu and bill listing prices. That's what the regulation says.
Counsel, how is shall not mandatory? I've heard may is not mandatory, but how is shall not mandatory?
Well, it shall include. It shall include. So what is notification? Notification shall include standing out in front of the restaurant with a bullhorn. That's notification. That's one way of giving notification. Conveying it in an email is another way of giving notification. When you look at the regulation as a whole, what you have sub A says you've got to give notification. And then sub B says the employer has the burden of proof on notification. And then sub C says notification shall include ...
Yeah, but I mean, this is also 3 sentences down. It's not even the same sentence in the shall include. This say the statement shall use ordinary language and shall appear. You know, this is 3 sentences later.
Well,
I'm not sure that that kind of funny way of.
The word include modifies statement, and then that last sentence that includes the 12-point font modifies statement. So what I'm saying is the concept of the statement that's in sub C, it's a safe harbor. It's one way you can notify a customer, but it's not the only way. And the point I wanted to make about Morgan's Hotel is this very regulation that we're relying on or that we're looking at here, it says the notification has to be in every document in the file. And this court, Your Honors, and 2 of you were on that panel, said no. You don't have to put it on every piece of paper. If you say it once in the contract and you say it clearly and unambiguously, no reasonable customer would be confused, and therefore World Yacht is satisfied, and therefore 196D is satisfied.
Mr. Rob, I think maybe you ought to, since you're already over your time, I'll give you 1 minute just to talk about this, the class certification, which obviously is a big issue. So could you just address why we should not go along with this class certification decision of judgment?
Sure. What the court said was certification, class certification is appropriate because all we have to do is determine whether the club is liable, and then the individualized questions regarding class members, well, that only relates to damages. Now, if the surcharge claim had survived, that might be an argument that carries some weight. But here, the individualized inquiries are not just limited to damage questions, but they actually go to liability questions, because with the surcharge claim dismissed, all you have is the question of individual patrons who voluntarily leave a tip. And then you get a whole host of individualized questions at that event. That customer leaving the tip, who did they give it to? Did they leave any instructions? You have to answer all of those questions on an event by event basis before you get to the question of whether the club could be liable for not distributing that tip in the way plaintiffs ask. And so it's not just a question of individualized damage inquiries. If this case were to proceed on a class basis, literally every event would have to be litigated to determine if there is liability, because there was no common policy with respect to voluntary tips that apply to every patron at every event. So
okay. I thank you both very much. We've looked at these other issues that you've raised, and we'll look again at your briefs. Thank you both for your time.
Thank you.
Nice afternoon. That was hard to hear. The next case for argument is Cohen versus Civ Paget. We'll hear from the respondent counsel first, Mr. Cohen.
May it please the court, my name is Morris Cohen and I represent the plaintiffs appellants in the present matter. Your honors, in the amount of time I've been speaking so far, Mr. Barshov could have explained my client's critical rights at issue. He simply had to say, Betty, if you put in a claim, your insurer will take over and cover all your attorney's fees. It literally took me less than 10 seconds to say that. Appendix A997 indicates that when Cy was hired, they spent hours having conference calls with Mrs. Cohen and researching. Hours. Out of all of those hours, they should have taken 10 seconds to explain those critical rights to her. In seconds, they could have literally avoided having my client spend 8 years paying hundreds of thousands of dollars in fees to attorneys. A client plainly needs information to make a fully informed decision. When Cy failed to provide that information, it departed from the duty of care. It's undisputed that they had a duty to sufficiently explain her rights such that she could make informed decisions. We called expert Mr. Michelin to the stand. He testified on this based upon 32 years of experience. And he said a client has to be explained. It's a very, as he said, quote, it's a very basic part of a lawyer's obligation to give clients information so they can make informed decisions. That's at
Mr. Cohn.
Yes.
Excuse me, this is Judge Shulman. This was a jury trial, and the jury had the opportunity to determine credibility of the respective experts, both Mr. Michelin on your client's behalf, and among the witnesses, Mr. Michael Troisi, who had many, many years as counsel with the Fireman's Fund, which is the insurer that's part of this process historically. And you know, and I'm just thinking out loud, so bear with me, that, you know, legal malpractice, but for the negligence, you would have been successful. And there was testimony that this jury heard that basically, I tend to wax local, threw the whole but for out of the woods, so to speak, in terms of your client having knowledge of the damages being done to her home from the neighboring excavation work in August of 2004, and there was a real issue. The whole heart of the disclaimer was the untimeliness of it, putting aside whether there's earth movement exclusion. I'm not really going there, but the jury heard all this, and the jury weighed Mr. Troisi and Mr. Michelin, and Mr. Troisi was the insurance expert, Mr. Michelin was the so-called universal expert or Renaissance lawyer, based on his website. And they did a credibility analysis. So then how are we to step in and disturb all that?
Your Honor, the jury verdict only was on duty of care and departure. The jury never reached the causation issue. They never reached the but-for. And on the issue of duty and departure, Mr. Michelin's testimony was unrebutted. There was absolutely no evidence put in by the defendants to rebut Mr. Michelin. In fact, Cy put 4 lawyers on the stand. They put 2 experts, and then they put 2 lawyer witnesses. They put Mr. Troisi, Mr. Kotula, Mr. Barshov, and Ms. Joyce. Not a single expert or lawyer disputed the fact that there was a duty of care to provide the advice to my client, and that advice was never provided. The jury did not get beyond that question, and there was simply no evidence to support a verdict for the defendants.
Well, counsel, excuse me. I thought, was the defendant retained for litigation purposes, or was the defendant retained for purposes of determining a possible violation because of the work that was being done?
The defendant was retained to protect our client's rights. There was no retainer agreement. Our client went to Mr. Barshov and said, my house is being undermined. The building department has just told me that. I need someone to protect my rights. And it's shown by the fact that Mr. Barshov did litigation and did everything else, that his retainer was not limited.
But I thought that your client was knew the defendant based upon the fact that he had done certain work in terms of building department violations, and that's how she knew him, and that's why she went to him to ask him about these potential violations.
She went to him to protect her rights because he had done work for her employer, Century 21. all sorts of different cases. He did his expertise was litigation, insurance, he says, violations, different issues. His retainer was never limited to one particular issue, and he never produced any retainer agreement or any other document showing he was limited. And in addition, in fact, he did do the litigation. We see that there were multiple litigations, 3, he handled all of them. So his representation was not limited to just looking up a code violation, which is now after the fact.
And then the other thing, counsel, I thought that the record indicated that he did, in fact, question her or ask her concerning the insurance and whether or not she had reported this to her insurance company, and that he claimed that she stated that she didn't want to do so because she didn't want the premiums to go up. And she stated, I believe, that she wasn't clear. She couldn't recall whether she actually had this conversation or not.
So, Your Honor, after a jury verdict, if we take all inferences in favor of the defendant and we assume that conversation took place exactly like he said, that's all the more reason he should have explained the critical information to her. If she was worried about her premiums, which were about $2,200, if she was worried about those going up by a few $100s, clearly she would have wanted to know that she could have saved attorney's fees, which were over $420 an hour. If she was worried about a few $100s, she would clearly be worried about tens of thousands or hundreds of thousands of dollars attorney's fees. Once he knew that she was worried about the premiums, he should have told her that there's even more money at stake, the attorney's fees of tens or hundreds of thousands of dollars. Clearly, if she's worried about a few $100s in premiums, she would have wanted to know that the insurer would have covered her attorney's fees, which would have been tens or hundreds of thousands of dollars, far, far more. And any reasonable client and any reasonable attorney would have to have that conversation. An attorney would have to provide that, and the client can't make an informed decision if they don't know that information. It was undisputed. She did not know that her insurer would cover attorney's fees. If she had, she would have. I'm sorry, Judge Kaplan.
No, I just want to say, I just answer that question, because then I'm going to stop you and you will have 2 minutes to rebut. So I'm sorry, go ahead and finish that answer.
Sure. When you consider the importance of the advice, the ease of providing it, if you consider how important it was for her a few $100s, it was all the more important that she be told that her attorney's fees, which were $400, not a year, but an hour, would be covered by her insurer. Thank you.
Okay. Mr. Naperty, on behalf of the defendant respondent.
Yes, thank you, Judge Kapnick. At the end of a very long day, this was about a 1,000-page trial transcript. The trial was fairly long. And as Mr. Cohn points out, there were a number of issues that were presented to this jury. But at bottom, what happened is the jury never got past the first question. And that was there a departure? They found that there was no departure from the standard of care. And Judge Chan, in her post-trial order at page A4 of the record, she distills the issues in this case with respect to the weight of the evidence analysis down to 3 very succinct paragraphs. And I would submit to the court that to arrive at the verdict that it did, to answer no to question 1A, all the jury had to do was make 3 very simple credibility determinations. Number 1, they had to reject Oscar Michelin's testimony as incredible. He conceded on cross-examination that he exaggerated his credentials, that he is not an expert in insurance law, that he is not an expert in legal malpractice, that he has modified his resume and bio on the website on various occasions to dovetail with the cases that he was involved in for Mr. Andrew LaVoot Bluestone, who makes his living suing attorneys and was a consultant on this case for Mr. Cohen. And the jury was also charged with given a falsus in uno charge, which very clearly says that if you find that a witness lied about something, then you can disregard completely the entire testimony of that witness. That charge appears on page 887 of the record.
I think we've all given that charge.
Of course. So once you toss out Mr. Michelin's testimony, the next credibility determination for the jury was there ever any discussion, right? So you have Michelin who's trying to tell the jury what the standard of care is, this exaggerated discussion that should have taken place, essentially shoving it down Ms. Cohen's throat that she should exercise these rights. So we toss that out the window and you say, the next credibility determination is, was there any discussion? And the jury was presented with the testimony of Stephen Barshov and Susan Joyce, both of whom testified that they were on a conference call with Betty Cohen. During that call, Mr. Barshov explained to her that you should proceed with making a claim under your insurance. And Ms. Cohen said, no, I'm not interested. And at the end of a long day, it doesn't really matter whether or not she was not interested in doing that because she was concerned about her premiums going up or she had some other reason. She said that she wasn't interested. And the testimony of Ms. Joyce and Mr. Barshov is that they didn't just stop there. They said to her, you have to be aware that there could ultimately be a disclaimer for late notice. And the testimony is that the response from Ms. Cohen was, I'm not worried about that because in essence, I have connections, right? I have a broker. I'm sorry, Judge Kaplan.
No, I was wondering that didn't Mr. Cohen, not the plaintiff, the lawyer, just said that shouldn't they have specifically told her that one of the benefits of their insurance policy might be legal coverage, legal attorney's fees, and was that alleged to have been told, or was that not necessary? I mean, that was his big points.
Yeah, so that allegation that is required within the standard of care, that came from Mr. Michelin, and I'm assuming for purposes of my analysis here in step 2 that Michelin's testimony was completely disregarded by the jury, which it had every right to do, and as did Judge Chan. So the question then comes, what is the duty of care? And the answer to your question is no. There's no allegation by Mr. Barshov or Ms. Joyce that he specifically said to her that your attorney's fees could be covered. But I mean, I guess I don't want to go off track here because at the end of the day, also, if you do analyze the testimony in this case regarding the issue of whether her attorney's fees would have been covered, we have testimony from Mr. Catula, who was our expert with 30 years of experience handling third-party claims, who said unequivocally that there is absolutely no way that these claims would have been covered. So if you toss out Mr. Michelin's testimony and you credit Mr. Catula's, which is what we have to presume the jury did here, then they can't find that it was a departure not to tell Ms. Cohen that she had rights that didn't exist in the first place. And I want to just stay on that pattern. So the third credibility determination here, and as Judge Chan pointed out in her decision, is whether or not Mrs. Cohen is a knowledgeable, assertive, and strong-minded person in essence, which the jury heard a lot of evidence on. And when Mrs. Cohen says, no, I'm not interested, Mrs. Cohen means, no, I'm not interested. And Mr. Barshov had a relationship with Mrs. Cohen. This is not the first time she walked into his office. And he knew her. He knew the Mrs. Cohen that he was dealing with, what his client was about. And he said to his client, according to the testimony that the jury allegedly, presumably credited based upon the verdict, he specifically was told, I'm not interested, and if I have a problem, I'll go to Jack Breyer, my neighbor, the broker, and he'll take care of everything. And still the testimony is he didn't end the discussion there. The testimony is that he said to her at that point, well, you have to understand, Ms. Cohen, that your broker is not the claims examiner, and the claims examiner could, and she said, I'm not worried. So at that point, what is he supposed to do? Mr. Michelin even conceded at page 505 of the record that you don't tell a client what to do. The client tells you what to do. And ultimately, it's the client's decision what to do. So at that point, the jury was free to make a determination that there was no deviation from the standard of care, whatever that standard of care is. And
can you just finish up, Mr. Naperty?
Yes, I mean that's really what this comes down to. That is what the jury found, and to get into everything else in this case, they didn't have to get into anything else. That was the credibility determination. There was no departure, and if the court has no questions, I'll rest on my brief. Thank you.
Thank you very much, Mr. Cohn. You have 2 minutes on rebuttal.
Thank you, Your Honor. What defendants leave out is why Mrs. Cohen did not want to put in a claim based upon their position. If we take all inferences for the defendants, the reason why she did not want to put in a claim was because she was worried about a $2,000 a year premium going up. She was paying $2,000 a year. What would have happened if it gone up 10%, 20%, 100%? We're talking about a few $100s to $2,000. Instead, Mr. Barshov withheld from her the critical advice that it is common for insurance to take over and to cover your attorney's fees, and then took her down a road where she paid tens of thousands of dollars to him and ultimately hundreds of thousands of dollars in the case. There is no dispute that if she had been told that her attorney's fees would be taken over by the insurer, she would have rushed to put in a claim. That was critical information. There's also no dispute that under the rules of professional conduct, whether 1.4b or formerly EC 7-8, an attorney must give a client sufficient information to make a reasonably informed or fully informed decision. She could not make that decision because the evidence in the record was that she had no idea that the insurer would cover her attorney's fees. If she had been told that, she would have literally rushed to put in a claim. By not telling her that critical information, which is undisputed, he definitely breached the duty of care. How could she take proper action when she did not have all the information at her disposal that she needed to have? It was his duty. That's why she was paying him for $20 an hour, to give him the particular advice that she needed. She wasn't a lawyer. She had no experience with insurance. The evidence in the record was clear and undisputed that she had never put an insurance claim before. She had no experience with insurance. She went to him to explain her rights to her, and to protect her rights. He did not do that. For all of his testimony, it is undisputed that he never told her the benefits that she would have gotten, and that's just one benefit. We're just whether subrogation, attorney's fees, the full cost replacement value. He did not tell her any of that.
Your Honors, just to correct a material statement of fact.
Wait, counsel, I didn't give you time to do that. So I appreciate it. We all have the record, and we will all take further look at it. Thank you very much for your time this afternoon. We appreciate the arguments.
Thank you, Your Honors.
Time. Okay, now the next case to be argued is People versus DiPaolo. Justice Shulman is recused from this case, so I'm not sure he's going to disappear now, right? Judge Shulman, you're going to somehow disappear. And Judge Peter Moulton here's Judge Peter Moulton has appeared. That was pretty efficient. Hello, Judge Moulton. Can you hear us?
Yeah.
Okay, great. So, fine. The defendant on the DiPaolo case, you may begin. Well, we don't hear you. You're still muted, Miss Adelson. Whoops. Uh-oh.
Now am I unmuted?
Now you're unmuted, yes.
And you can see me. Okay.
You can. Perfect.
Okay. All right. I apologize.
That's okay.
Our brief has raised many issues that go to the fairness of this trial. But for the purposes of this argument, I'd like to focus on two rulings that we believe eviscerated Mr. DiPaolo's ability to mount a defense. The first involves the ruling that precluded DiPaolo from showing that he had sources of money to fund the Argents that were unrelated to Pangea. The price of admission for the defense establishing that DiPaolo had made substantial capital contributions to the Argents would be allowing the prosecutor free range to tell the jury that DiPaolo had committed certain improprieties, we don't know what, but because they were never proven, but certain improprieties with respect to prior investment vehicles. In other words, to tell the jury he had a propensity for committing fraud, which is exactly what Molyneux forbids. And the second issue I hope to touch on deals with the successful efforts to silence Gary Schoenwald, who is counsel for the Argents, but also a corporate officer. Before I address those issues, I would just want to make one quick point. This was a very long trial, and it seems like it's very complex, but really the financial issues come down to two basic questions. Number one, did DiPaolo contribute $2 million to the Argents that would justify the PPM's full disclosure that he was entitled to take $2 million from the Pangea proceeds as a return of his basis? And second, did he take more than $2 million from the Pangea offerings during the course of the offering? In both cases, the answer is he gave more than $2 million, he took less than $2 million, but he was severely curtailed in his ability to show this by the court's rulings. So turning first to the claim that the prosecutor made throughout the trial that Mr. DiPaolo never had financial resources to contribute funds to the Argents. This wasn't true. But
well, counsel, excuse me. I don't believe, my reading of the record, I don't think that there was an actual ruling by the court as to the Molyneux application. My reading of the record was that defendant stated that he wanted to make the showing that he was independently wealthy and he had all these legitimate sources of income. Excuse me. And I thought that the court just said, you know, if you do put forth that type of evidence, then you may be opening the door for the people to now step in and to present evidence to the contrary. And so I didn't see an actual ruling by the court stating that the people would be able to bring out these prior bad acts on the part of your client.
Well, there was an actual Molyneux ruling because the court initially said, I don't see a direct link in these prior investments to this case, and you haven't shown me it's probative. So this, what you're telling me in generalities about prior misconduct is excluded. And then there followed a barrage of complaints by the prosecutor, and the court stepped back and said, well, wait a minute. Okay, there's many ways that I may change that ruling and allow the prosecutor to introduce this type of evidence if you so-called open the door. Now, what the prosecutor was arguing is that the jury was entitled to know that these other sources of money were dirty. That was the word that was thrown around the trial. But he never explained why it was relevant to the Argent investors to know where DiPaolo's money came from when he funded the Argent. There was no direct link to Pangea. And it was highly prejudicial to simply suggest that that money was dirty without showing that it was more probative than prejudicial. And this was a constant refrain throughout the trial, that if you go there, you're opening the door. And I want to take one very tiny instance of it that shows how unfair it was.
Well, counsel, I don't understand. Did the prosecutor ever introduce that evidence?
The defense was very, very, very careful not to provoke the court's wrath and open the door. But I would like to give an example of the kind of thing that happened, because it happened throughout the trial 20, 30 times. It's really hard to capture it. But a jeweler gets on the stand and testifies that after the Pangea offering, I extended credit to DiPaolo so he could buy all these watches. Well, that gives rise to an inference. He was using the Pangea money and only had the Pangea money to buy these watches. On cross-examination, defense counsel wanted to ask Julia, well, haven't you been extending credit to Mr. DiPaolo since 1996? And hasn't he bought watches from you in the past? That led to at least 30 pages of sidebar about how that simple question to show the truth of the matter, which is that he had done this in the past, was opening the door. So no, the evidence did not come in, but only because defense counsel was so clearly frustrated in any attempt to establish for the jury that Mr. DiPaolo was not a pauper and he had invested a tremendous amount of money in the Argents before the offering, and he had contributed to the Argents during the offering much less than he was entitled to. I would like to quickly turn to Gary Schoenwald, if I may. I see my time
Yeah, you have
Do
about
I-
1 minute. You'll still have a
Okay.
couple of, but if you want to just
Okay.
mention it, you can finish it later.
I just want to mention Gary Schoenwald. There were two areas where the prosecutor was able to silence Gary Schoenwald. The first had to do with this ruling that Schoenwald could not testify as a fact witness without raising the advice of counsel defense, and that would require the defense to waive the attorney-client privilege at the advance of trial before he even knew what the prosecution was going to say. Schoenwald had a lot of information he could have provided as a fact witness that was relevant to this case, and he was precluded from doing so. The second was worse, because this corporate resolution that was excluded would have showed that Argent US transferred 10% of its shares to Pangea in September 2010 as the PPM represented. The prosecutor took the position that corporate resolution was backdated. The only person at that point who could authenticate it, because the metadata was not available and the defense told that, was Gary Schoenwald. And he was prepared to come in and say, as an officer of the court, I prepared that resolution contemporaneously with the transfer. I can authenticate that resolution, and this whole prong of the prosecution's case falls apart.
But I thought he took the fifth. Didn't he take the fifth?
He did take the fifth because he was told repeatedly, unequivocally, that if he got on the stand and said that he prepared that resolution contemporaneously with the transfer, he would be prosecuted for perjury. And that is precisely what Webb v. Texas, People v. Shapiro, the Court of Appeals case say is effectively driving a defense witness from the stand. It was a blunt instrument of intimidation that precluded his necessary testimony. And I apologize, but I am terrible with technology. So
Okay. Can we, we'll hear from the other side. She'll have 2 minutes for rebuttal.
Thank you.
Okay. Mr. Hughes?
Yes, good afternoon, Your Honors. John Hughes for the People. I'd like to just start where my adversary left off regarding Gary Schoenwald. The prosecutor never said that if Schoenwald testified that he would be prosecuted or anything like that. The reality is Gary Schoenwald was very closely involved in defendant's fraudulent securities offering. He was very closely involved in many ways. He helped participate in the drafting of the PPM, which contained numerous misrepresentations, numerous false promises. And so in that context, the prosecutor, like early on, advised the court that, in fact, he had potential criminal liability and therefore he should have a lawyer present just in case. And also, Schoenwald's own attorney later on during this trial actually even told the court that, it's not that Schoenwald took the fifth because he was worried he would perjure himself. Schoenwald was only concerned about his liability concerning past criminal offenses. Furthermore, the prosecutor even actually at times was encouraging Schoenwald to testify, saying, look, if Schoenwald is going to testify truthfully, he should absolutely do so. And so it simply is not a threat to comply with our ethical obligation to advise someone in this situation that they should just consult with a lawyer when they're in this kind of situation. And indeed, had the prosecutor not recommended that Schoenwald consult with an attorney, that the court not done that either, well, that would arguably be an ethical violation on our part. And furthermore, the defense would likely turn around and be, claiming something about a perjury trap if indeed he took the stand and said something that later turned out to be untrue. And so, the real gravamen of all the relevant rules here is just that you can't badger a witness into not taking the stand, but we're obligated to advise people if they're about to take the stand and they have some potential liability.
So did the court actually say that? I thought that the court ruled that Schoenwald could be called as a fact witness, but could not testify as to using advice of counsel. But I thought the court said you could testify as a fact witness.
That's correct, Your Honor, because the defense made a proffer, because later on during the Pangea offering, Schoenwald, I think in 2012, 2013, Schoenwald became the CEO of one of the Argent companies, and the defense made a proffer about things he could testify to that did not involve the advice of counsel, and the court agreed and allowed them to do that. But of course, in the end, Schoenwald took the fifth. Now, just in the interest of time, I'd like to go ahead and switch over to the Molyneux issue my adversary mentioned. Now, throughout, both the briefs and again here today, defendant has argued, he was precluded. That's not true. He wanted to introduce evidence about all of this outside income, and and he wanted to introduce that to try to say, oh, well, I had all this other money that I sent to the Argents, and that should offset the money that I took from investors. Well, here's the thing. Defendant can't claim credit for transfers that he made using other people's money, and that's really one of the main points of this Molyneux application, was that if defendant wants to show that he had all this other money and that he sent it to the Argents, and that that defendant should get credit for that, well, it's very important that those are his funds, that he has them legitimately. Otherwise, that eviscerates the whole legal point of him having that. And this was really ruling just about what would open the door. And the court made clear, if defendant really wanted to put this evidence in, he was free to. And furthermore, many of defendant's arguments seem to be about, addressed to the admissibility of this Molyneux evidence. Well, Justice Weber, as you sort of pointed out, this never came into evidence. We made an application pre-trial to bring it in during our case in chief. We were denied that. And in fact, throughout the trial, defense counsel engaged in a lot of cross-examination that really kind of suggested things about defendants like outside wealth. They made suggestions about all this money that he had supposedly sent to the Argents and everything. And on many occasions, the court even said, look, I think you have opened the door, but I'm still going to prevent the people from bringing this Molyneux evidence in. So, at the end of the day, this was really a strategic, victory for the defense, because they managed to keep out all of this Molyneux evidence, even though the court had said that the defense had actually opened the door to that. And just generally, Your Honor, I'd just like to point out as well, at this months-long securities fraud trial, there is simply overwhelming evidence that defendant defrauded his investors out of the entire $6.5 million. He made just a wide variety of misrepresentations and false promises in the PPM, one of the key documents in this matter. And really at the end of the day, there was simply just overwhelming evidence of defendant's guilt, both as to his fraud and as to the money laundering charges, and of course, the tax charges as well. And also many of defendant's other claims just involved discretionary rulings by the trial court, and particularly in the trial of this length. The trial transcript itself was on the order of about 7,000 pages long. I think the deference to the trial court's discretion is particularly appropriate in a case such as this. And if Your Honors don't have any other questions, we'll rest on our brief and ask that you affirm. Thank you very much.
Thank you, Mr. Hughes. Ms. Edelson, you have 2 minutes. Oops, you're still muted.
I feel like, okay, I'm going to respond to 4 claims. Yeah, I do. I need it. And I do apologize, but
that's okay.
Age. The 4 specific claims made by Mr. Hughes. First, he said that that Gary Schoenwald was never told he would be prosecuted if he would testify about the corporate resolution. On page 25 of our reply brief, I'd like to read a few comments that were made during trial. The prosecutor said if Schoenwald were to testify about the corporate resolution, he would, quote, perjure himself. Second, to be, quote, very, very clear, if the witness were to now say some destroyed computer that cannot be found, I at one point created the document. If that person wants to say that under penalty of perjury, then he will face whatever consequences. And third, we're in possession of his computer. If he were to get up and say, testify about the resolution, we would have the right to seek a judicial search warrant to go to the computer and determine whether or not he perjured himself. These, as I say, are not gentle reminders of an ethical obligation to a seasoned attorney. These are threats of perjury. The second claim I want to respond to is the fact that Laura Bravetti, his criminal counsel, said she wasn't concerned about perjury. That's just not true. It's a little confusing passage, and it's at page 5004 of the transcript, where after there's a back and forth about this issue, Bravetti says she's not going to tell him to take the fifth on account of perjury because she's more concerned about past offenses. But then she follows it up that she's going to advise him to take the fifth based upon the proffer, which was only about the corporate resolution and the court's ruling on the proffer. So I think the issue here was the perjury threats relating to the proffer. The third thing is, no, Gary Shulman was not permitted to testify as a fact witness as counsel. The ruling after many, many fights was that he could come in and testify as a corporate officer for the period late in the offering after August, I think, 2012. He could not testify as a fact witness when he was counsel, for instance, as to such matters as to whether he drafted the PPMs, which the prosecution witnesses denied happened, although they proffered otherwise, and to say what he intended certain provisions to mean, and to give some back the case. And finally, the last thing is that they keep saying it doesn't matter, you know, if he had what money he gave to Pangea during the offering, but the crux of their claim was that he had never made capital contributions during the, you know, before the offering, and showing that he had vast sums of money and used his money to support the Argents beforehand and was entitled to a return of the proceeds was critical to the defense case. And other than that, as to the overwhelming nature of the evidence, I rest on my briefs.
Thank you both very, very much. Appreciate your arguments this afternoon.
Thank you, Your Honors.
Thank you, Your Honor.
I apologize again.
No problem. Now, the last case is U.S. Bank. And in this case, I am recused from the case. So now I am going to leave, and hopefully Judge Shulman will come back on and you may have your argument. Thank you very much. I'm leaving.
Bye.
We're waiting for Judge Shulman.
Shall I send them a text?
Being done. But you can text him as well.
Okay.
Reasons.
There we go. Excellent. That was quick. Thank you. So, counsel, you have 5 minutes.
Thank you, Your Honor. May it please the court, John Sarando, on behalf of the Appellate U.S. Bank Trust, appealing from an order denying the motion for summary judgment and dismissal of the foreclosure action. The one issue I think that's dispositive of the case is that the trial court failed to toll the statute of limitations provision during the period of time that the lender or the borrowers were in bankruptcy. And when you add those 413 days, it gives a period beyond.
Counsel, this is Justice Moulton.
Yes, sir.
The first time you mentioned that, I believe, was in your reply brief in a footnote. Is that correct?
Yes, Your Honor. And
so why wasn't it brought up ab initio at the beginning?
I don't know, Your Honor. I wasn't trial counsel, but the trial court indicated that the defendant had an opportunity to respond to that issue at the time of the argument of the proceedings in Supreme Court. So it wasn't something that it wasn't something that that wasn't fully able to be litigated. It was fully litigated. And we submit that when you add the tolling provision, that the revocation was timely and the action was timely commenced. And under the terms of the mortgage itself did not, an action did not accelerate the debt by the clauses 19, 21, and 22 of the mortgage. So we submit that the action is timely and the trial court should be reversed and the foreclosure action reinstated.
So the discontinuance of the action occurred, the discontinuance was after May 2017, wasn't it?
The discontinuance was on, excuse me, the date was discontinuance was June 29th of 2016. That was the discontinuance of the prior action. The time for the statute of limitations to expire with the bankruptcy tolling was February 2nd of 17. So this was within the grace period, what they did. It's similar to the tolling provisions in a speedy trial analysis in the criminal vein. And the motion to discontinue was also timely. And that motion then also withdrew the acceleration.
Withdrew the acceleration?
Yes, the motion itself would withdraw the acceleration because it's an affirmative act to revoke the acceleration. It's similar to, I think, in the Charvola case cited in our brief, it's similar to an indication where an allegation in the complaint revokes an acceleration, where the party says they're revoking the acceleration. So that would be similar because it's a sworn statement in an affidavit submitted to the court.
Did the de-acceleration letter have to be sent to the Board of Managers here?
I don't believe so. No, I don't believe so, because they were not proceeding under the theory of an improper transfer of the collateral without permission of the bank. They were not submitting that. But insofar as the condominium, the corporation is concerned, they did not raise any. The only defense they raised was the statute of limitations that gets us here. So they did not object, I think, to any of the jurisdictional aspects of the case, other than the statute of limitations period, which we submit was told by the bankruptcy of the predecessor. And we would ask that the court reverse and reinstate the foreclosure action.
Thank you, counsel. Any further questions? No? Thank you. That concludes the oral arguments for today. Court is adjourned. Thank you.
Thank you.